How long can information collected during interception be retained? The interception rule requires that all records, including electronic records that are part of an interception order to be destroyed by the government organization in every 6 months, apart from a case where such information is obligatory or likely to essential for practical purposes. In the case of monitoring and collecting of traffic data rules 2009, this period is 9 months from the data of creation of record. Additionally, complete records relating to the order for the interception and monitoring are to be allowed by the intermediary during the time of duration of 2 months immediately after the discontinuance of interception or monitoring. If they are needed for every continuing investigation or court trial with reference to the monitoring rules, duration provided is 6 months since the date of discontinuance. Punishment is provided to intermediaries and subscribers for refusing to comply with the order for interception. Section 69 specifies a punishment of imprisonment up to term of 7 years and fine for any subscriber or intermediary or any person who fails to assist the agency authorized to intercept. Now, we will be moving towards the next chapter, that is online censorship and online surveillance. A department of the Ministry of Communication of Information and Technology that serves as a nodal agency for accepting reviewing requests from designated pool of governmental officials to block access to specific website. This chapter will provide an overview of how takedown requests in presence and absence of judicial officers are issued on regular basis. This discussion further states that companies occasionally facilitate governmental censorship by acting in accordance with governmental requests along with filtering and blocking policies. These processes are varying and often infringe upon the freedom of expression in India. With so many procedures being used to confine online speech, there is an active deliberation in India about the effects of censorship on fundamental freedoms and society. The words such as an obscenity and incitement are not defined, owing to the ambiguity of the legislation, firstly, and secondly, the obligations of the legislations as to the interception of this term is subjective. The imposition of legislation has headed to the people being under arrest and accused for offensive posts and tweets. The Information Technology and Information Technology Amendment Act have not provided a distinct definition of the term offensive, and there is no regular public view of the concept of online and offline amount to vagueness, which has caused in rising propensity to report information considered offensive and request its elimination. Intermediaries, web business corporations that host information, however, do not create the content, and there is little incentive for intermediary to resist complying with the takedown of notices out of concern of being held accountable of the offensive content and then put on a trial. The excess over compliance of internet intermediaries with takedown notices is concerning as it eliminates legitimate speech from the internet. Solving this is difficult in absence of an appeal procedure. Intermediaries in India are not required to inform people if their posts or photos are removed, nor give individuals a chance to appeal the removal. Next sub-point for the further discussion is takedown request, and further point of discussion is provided under the image 1, which describes intermediary liability. Please have a look for the purpose of better understanding over image 1. Now the next chapter for the purpose of discussion is criminalization versus decriminalization of online speech. In 2011, Google, Facebook and Yahoo were asked to design a mechanism that would pre-filter inflammatory and religiously offensive content. This request was not only technologically difficult, but it was also strong attack on free speech. Also, the criminalization of online speech in India became a matter of great worry as numerous government establishments took legal action against dogmatic statements made online and individual opinions communicated on social media. Different speech openings available on social networking media in India have been objected after the passing of Provision 66A of the IT Act, and arrest of number of Indian citizens for placing offensive information have been done. This chapter looks at in what way Section 66A was violative of the right of freedom of speech and expression. Section 66A of the IT Act was being both overly broad and was defining disappropriate penalty. This section was added to the IT Act 2000 by amendment in 2008 with the view to penalize the communication of information which is grossly offensive or has menacing character, or any information which can cause annoyance, inconvenience, obstruction, insult, enmity, hatred or ill will among the other potential grievances. The provision carried a penalty up to 3 years imprisonment and a fine. Please have a look over the provision of Information Technology Act provided below. Much of the 2008 amendment to the IT Act has its origin from the 1935 UK Post Office Amendment Act, which is linked to phone calls and telecommunication messages. Instead of amending the legislation to eliminate these provisions as they were not framed to address digital communications, the Indian government adopted them into the Act. With this specific regard, there had been number of arrests done under Section 66A of political condemnation on Facebook, Twitter and even via private email. This was disturbing development that demonstrate a clampdown on political speech, including speech that may have a public interest purpose which should have been safeguarded. Criminal and civil cases registered against many of the internet companies for weakening to take out information considered by several people to be defamatory or religiously belligerent. This amount of censorship was uncalled for in an operative democracy. We will be discussing this thing in the next case study which we are going to discuss, that is Facebook post and apprehensions. For the purpose of better understanding, please have a look over the post mentioned by Shaheen Danda on Facebook with respect to the Shiv Sena chief Bal Thackeray, and the post tweeted by Ravi Srinivasan with respect to the son of former finance minister Mr. P. Chidambaram. This prevalent disgust against the misuse of Section 66A caused the Ministry of Information and Communication Technology to issue a guidance to states on how to implement the controversial section of IT Act. But there were continuing questions linked to political intrusion in the execution of law to the indefinite phraseology of the legislation itself, with the use of the overly broad terms such as annoyance, inconvenience, by giving organizations a comprehensive scope to criminalize comment and opinion. Beyond the guiding principles issued in 2012 to stop the exploitation of Section 66A, an amendment in the legislation itself was required to avoid warrantless apprehension of under trials. In 2002, there was another case happened with respect to Asim Trivedi also. In January 2003, Rajiv Chandrasekhar, member of the upper house of the Indian Parliament, filed a petition to the Indian Supreme Court challenging Section 66A and the Information Technology Intermediary Guideline rules for being arbitrary and uncanalized and in violation of the right available to citizens under Article 14, 19 and 21 of Constitution. In all 10 cases came up before the Supreme Court of India challenging various provisions of the Information Technology Act, the rules made thereunder and the other laws that got heard jointly in the case of Shreya Singhal versus Union of India. The judgment delivered on 24th of March 2015. Kindly refer table below for the better understanding of all 3 cases which have got disposed of on different points. While delivering the judgment in conclusion, it was held by the Honorable Court that Section 66A of IT Act is struck down in its entirety, being violative of Article 19(1)(a) and not saved Article 19(2). Section 69 and Information Technology Procedure and Safeguards for blocking for access of information by Public Rules 2009 are constitutionally valid. Section 79 is valid subject to Section 79(3) being read down to mean that an intermediary upon receiving actual knowledge from a court order or on being notified by the appropriate government or its agency that unlawful acts relatable to the Article 19(2) are going to be committed, then fails to expeditiously remove or disable access to such material. Similarly, the Information Technology Intermediary Guideline Rules 2011 are valid subject to Rule 3 Sub-Rule 4 being read down in the same manner as indicated in the judgment. Section 118D of Kerala Police Act is struck down being violative of Article 19(1)(a) and not saved by Article 19(2). All the writ petitions are disposed of in the above terms. Next discussion is about the status of unique identification number and Aadhaar card in India. For the purpose of better understanding, please have a look over the case which is discussed below in the chart. Unlawful Identification Authority of India and another versus Central Bureau of Investigation. The case is divided under the fact, issues and held. In March 2014, the Supreme Court of India ordered an ad interim relief in Unique Identification Authority of India and another versus Central Bureau of Investigation. Please have a look over the case analysis given below for the purpose of better understanding. The case analysis is done under the two different headings, that is fact and held and the appraisal of the case. After the discussion regarding the UIDAI case, we are heading towards concluding today's discussion. For the better understanding, conclusion is divided into three parts, that is an analysis, then findings and then recommendations. While analyzing this topic, this is the time for Indian government should take into the consideration the right to privacy and safeguard from arbitrary intrusion with one's privacy, speaking about major surveillance and unjustified digital interceptions in India are both essential stages to combat self-censorship and to endorse freedom of speech and expression. Being proliferate the emerging nation, India has to create strong guidelines and procedure in order to defend IT industry as well as to guard privacy of all citizens, considering above discussed facets of cyber surveillance. For the purpose of analysis, kindly have over the 3 points mentioned in the chart below. Now, with respect to the findings, for the purpose of better understanding with respect to the findings, please have a look over the image 2 provided below, whereby the concerns have been divided into the three parts, that is judicial concern, investigative concern and then the legislative concern. Then coming to the recommendations, have been summarized to resolve the concerns as mentioned in the analysis and finding which we have discussed earlier. For the purpose of better understanding with respect to the recommendations, please have a look over the image 3 provided below. And at the end of the discussion, I would say thanks for listening patiently. Thank you very much.